the biggest nation that follow the rituals and religion. And one of the most sacramental form of relationship is said to be as a relationship between a husband and a wife. But when these sacramental relationship comes in the circumstances of violence and the circumstances reach to such a point that they cannot live together, then the concept of divorce and the concept of living separately comes into play. And one of the most important sections that we have in our Indian legal system is Section 498A of IPC that actually talks about safeguarding the innocent wife from, from the misuse of law and misuse of power by the husband. And today in this presentation, I'm going to talk about especially focusing on husband's rights and legal protection against misuse of Section 498A of IPC. If there is the presence of law, if there is a misuse of law happening continuously in the nation, continuously in the judicial system, then also we need to see what steps must be taken to protect the rights of husband. That's what I'm going to talk about, especially putting my focus on that concept. The first thing I want to communicate in this presentation is about what 498A IPC actually says. It actually says it is said to be as a social legislation that protects women from cruelty by husband or his relatives. Whenever there is a marriage takes place, and after that, after the circumstances followed, and a wife is said to be continuously harmed by husband or by the relatives due to dowry or maybe due to any other reason, this is said to be as a problem that is created by the family as well as by the husband towards the wife. And the Section 498A of IPC is for the same, to protect the wife from all these problems. However, when times flow upon, concerns of misuse have emerged. Wife has a very good right, very big right of 498A of IPC, but the misuse has emerged immensely in the overcoming times, leading to innocent husbands and families facing harassment, social stigma, and legal terrorism. Now, I like to focus upon the word legal terrorism. What is legal terrorism? If I will explain it up further, let's divide the word into two forms. One is legal, one is terrorism. Terrorism, we all know what it actually means, but when it is practiced legally to harass a particular individual or the relatives or the family of that particular individual, that is said to be as legal terrorism. So we can relate that harassment can also be channelized as legal terrorism when it is continuously being practiced upon an innocent person. And in context to this concept of 498 IPC, when this particular thing is practiced upon the husband continuously, it is said to be as a legal terrorism. And including this social stigma, a family loses all his or her reputation in the society when they are booked under 498A of IPC or any other legal proceedings. The Supreme Court and law commissions have acknowledged the imbalance and need for reforms. Multiple times, Supreme Court, as well as other law commission has prescribed that yes, reforms should be there in context to this concept what we are all discussing here upon. And yes, changes are needed with changing times in this country in the Indian judicial system. Now, let us talk about the objective of the presentation that I have made upon. First, to analyze the misuse trends of 498 of IPC. What are the trends that actually signifies that yes, 498A of IPC is also used for misuse in this country? Secondly, to highlight judicial safeguards and rights of husband. We must highlight the judicial safeguards. What are the rights that the husband have that he can practice upon when he is booked under 498 of IPC. Third is to propose balanced reforms ensuring justice for both genders. We can actually formulate some of the required reforms that are required for the upcoming times, and a balanced decision can be made for both the genders, hence for husband and wife. A common decision can be made so that will be both will be in a beneficiary side. Next, first of all, let us understand Section 498A. The 498A of Indian Penal Code 1983 talks about it is a punishable offense. First, it is non-compoundable. Second, it is non-bailable. Third, it is cognizable offense. Now, I'd like to elaborate all the three concepts that I am talking about over here. First, what is non-compoundable? Any offense which cannot be compromised. Both parties cannot come into a particular decision so that both parties can be beneficial over here. That is said to be as non-compoundable. When both parties cannot compromise for that particular offense, that is said to be as non-compoundable. Secondly, it is non-bailable offense. Any offense that you cannot take any kind of bail after that offense has occurred is said to be as non-bailable. Third, a non-cognizable offense. Any offense that is too grievous and a police or any authority can arrest the particular accused without prior information or without prior arrest warrant. That is said to be as cognizable offense. Cognizable offense may include dowry death, rape, murder, and so on. Moving further, let's have a reality check of what is actually happening in our country by multiple facts and multiple reports that I have indulged in this PDF. First of all, according to National Crime Records Bureau (NCRB) data of 2022 and 2023, first thing that I would like to put upon in this presentation is over 1.2 lakh cases registered annually under 498A of IPC. This is just a factual number that actually speaks upon how many cases are registered annually in 498A of IPC in the period of 2022 to 2023. Secondly, conviction rate alarmingly low at around 14 to 15%. The conviction rate as compared to number of cases that are registered in an annual year, it is quite low, that ranges to 14 to 15% just. Third, the acquittal or withdrawal rate is over 80% in this case. Fourth, more than 3.5 lakh men and family members arrested yearly, often without prima facie evidence. Now, this is the point that we all need to look upon. More than 3.5 lakh men and family members are arrested without prima facie. Now, what is prima facie? It talks about the first instance or first evidence. Without prior investigation, without prior getting of evidence, more than 3.5 lakh men and family members are arrested who are booked under 498A of IPC. Fifth, data reflects weaponization of the law in matrimonial disputes rather than genuine protection of victims. Now, this is the point where we all need to think upon. The act, what we all are talking about, 498 of IPC, has not just been an act anymore in this country. It has turned out to be a weapon for women for actually falsely acquiescing men under this section. Yes, there have been multiple cases that women are facing violence inside their home, inside the four walls of their houses. But what about those men who are not responsible for that particular offense? Now, this is the point where women use this section as a weapon. That's why I have formulated point number 5. Data reflects weaponization of law in matrimonial disputes. Next is the alarming observation that we all need to see. According to the NCRB data 2023, 89% of arrested women, mother, sister, relatives of husband are ultimately acquitted. Any any of these people whom I have taken the names, any of the relations that I have taken, 89% are acquitted with acquitted after the investigation. Secondly, according to the report of NCW, Internal Report 2023, over 35% complaints under 498A found to be exaggerated or frivolous after primary inquiry. As I said earlier on, now let us just link point number 5 of the report of NCRB and the report of NCW over here. The weaponization of this law as well as the exaggeration of the accusation made upon a husband according to 498 of IPC clearly symbolizes that yes, now this law needs to be changed, needs to be actually amended in the upcoming times. Because due to changing society, due to changing demands of society, due to the changing hybridization of people, the way what people think, how the crime is changing gradually nowadays, the amendment also is demanded in 498A of IPC, because as you can see by the report of NCW, over 35% complaints under 498 IPC are found to be exaggerated. Means whatever the extent, whatever the gravity of the offense was, it was shown that the gravity was much more than the real gravity, right? This actually takes us to a point to think that is the law even giving a equal right to both the genders? I think we must think upon this point, and according to me, yes, it is more lying towards the women that yes, they can exaggerate the things and show to the judicial system that yes, there have been some sort of crime has been committed upon them. Next, now let's talk upon some judicial remarks that have been made. First of all, the Supreme Court in Arnesh Kumar versus State of Bihar 2014, they have said that arrest is not mandatory in all cases under 498A. Automatic arrest is a violation of personal liberty. Officials must comply with the parameters of Section 41 of CRPC. First of all, it directly speaks. Supreme Court has given its verdict in 2014 that automatic arrest is a violation of personal liberty. The Article 20 that we all talk about. No arrest should be made without prior investigation of what that case was actually about. That is all that has also been seen in Section 41 of CRPC. Second important case law is Preeti Gupta versus State of Jharkhand 2010, in which large number of complaints filed under Section 498A of IPC are not bona fide and are filed with oblique motive. Recommended to the Parliament to review the law and make it less prone to misuse. Now, going 4 years back again, in 2010, the Supreme Court has again given its verdict that yes, the Parliament needs to review the law and make it less prone to misuse, because large number of complaints filed under this section are not bona fide and are filed with a motive to oblige the offender. Yes, again, the Supreme Court's verdict says that review and amendment in this particular law is very much necessary. The third thing